So, and of course, the other thing that points out in the bulletin is that there's nothing to protect people of a certain eye color from invidious discrimination. Nothing. There's only 7 categories. Also,
Can you turn away the patient if you don't like?
before they become a patient, yes, you can refuse anybody pretty much for any reason, but most of that tends to be behavioral type of thing. But I think it's kind of like a company that cannot hire anybody that they don't want to hire. If there's a pattern that becomes evident that they're not hiring people of a certain ethnic group, or they don't want to hire women, that's why all these companies are into diversity. So they want to be able to prove to the government that, well, we are diverse. It's, we don't depart that far off from the numbers of the general population. So at any rate, we'll get started here. Of course, if you stumbled into the wrong church, this is the North Texas Church of Freethought. It's July 1st, 2018. Oh, need to plug this in first. Hang on. I always think I'm ready to go, and then I'm not quite ready to go. Brandon, would you do me a favor? The batteries in this recording thing need to be changed out. Just pop the back off there, change the batteries out. Time. No, we're not. All right, so in a few minutes, we're going to enjoy a presentation by Rex Burks and Owen Younger. I forget which one of you say is the more good-looking one.
I'm the tall one.
It should be self-evident. Like these trees.
So Rex is an attorney, and so when they were together, yeah. Good. All right, so after the great March presentation, I thought, well, in July we usually do a state-church separation, talk about the wonderful constitutional protections we have for religious liberty, a separation of church and state, which are really the same thing. I asked Rex if he would please come and present, so really looking forward to that, and he has a part for Owen to play as well. These are really big subjects, of course. These are matters of ultimate concern, as the 20th century theologian and existential philosopher Paul Tillich put it. So I think we all, know a lot about state-church separation, but I don't think we should ever assume that we know everything there is to know. There's always more to consider, and of course it's always evolving. We've had some Supreme Court cases just last month, and one of them is covered a little bit in the bulletin. But first, some introductory remarks about our church. And we are, of course, very obviously both the same and also very different from all the other churches in town and across our nation and world. We're the same in that we have our matters of ultimate concern. We're the same in caring about these very important questions, and really the big puzzles of life and the most profound elements of the human condition, of what has been called the human predicament. We are the same in supposing that this is at bottom what religion really is. And I think also the same in that we gather together because we like to learn together, and even the Bible has us think about how iron sharpens iron. We learn better and further when we have other people around to challenge what our thoughts are. But we're very different, of course, too, in that we reject not just deities, but supernaturalism. We make this life and its problems the central focus. We do not suppose that we're just waiting to get into the next life where all will be made right, where every question will be answered, and every tear will be wiped away. We don't worry about where we're going to go when we die. We're concerned with where we are right now and having something to look forward to while we have the time to do so. No, I'll adjust this a little bit so it's not quite a little bit too loud. So this means that while the way we understand and consider religious questions, whatever anyone would want to consider to be a religious question, that's our religion, our views, our opinions. And we cannot accept the popular term, because we reject supernaturalism, we cannot accept this popular term that believers want to equate with the adjective religious, and you've all heard it, right? Faith-based. No.
Thank you.
Our viewpoint is one of doubt, not faith. That's not to say that we doubt everything anymore, that believers take everything they say they believe on faith. But we can be said to have one message, is that we should all, everyone should, have in mind that we are fallible with respect to our beliefs and understanding. To put you in mind, who says they're infallible, right? So we're the opposite of that. And in fact, we say that this fallibility is a tremendous strength, not a weakness, because it means that we can learn, that we can grow, and that we can literally get somewhere in any sense in which it matters, but especially spiritually in this non-supernatural way, meaning mentally, emotionally, existentially, and more. It's impossible to truly think about anything without doubting, without having and being aware of that element of uncertainty, of not quite knowing where facts and reason may lead us. Why would you need to think if you knew what the destination was going to be? And more consequential than any delusion of God or supernaturalism is this delusion of believing that you're thinking when really there's already a commitment to a conclusion. The only pre-commitment we ought to have is that facts and reason can be trusted in the now. Now, such trust may sound like faith, but it's not. And the believers do try to conflate this. Oh, well, you have faith that when you sit in this chair, it's not going to collapse under you, and so on. But the believer's faith is not like that. The believer's faith is a departure from facts and reason. Trust in facts and reason, which are the preconditions of thinking, is a naked moral imperative. It's a trust in the only thing that we have to make sense of things. Any departure from which is a violation of that trust. Think about that. It's really just a choice between sanity and insanity. That is the only thing about which we need not doubt. So 160 years ago today, July 1st, 1858, there was a joint presentation in London at the Linnaean Society by these two people. Charles Darwin, usually you see the older picture of him, but when he was younger, the photographic quality was just developing, and this guy, Alfred Russel Wallace. This was the first public announcement of the theory of evolution by natural selection, and they called it, the title of the presentation was On the Tendency of Species to Form Varieties and on the Perpetuation of Varieties and Species by Natural Means of Selection. Darwin's book On the Origin of Species, of course, we're familiar with that. That came out the following year, was actually an abstract of a larger work that he'd been writing, kind of quickly culled a bunch of things down, boiled it down. On July 1st of 1770, we should turn this front light off so you can see this a little bit better. Lexell's comet made the closest observed approach to the Earth of any comet. Here would be the Sun, over Mercury, Venus, here's the Earth, and this comet came within about 6 radii of the orbit of the Moon. So very, very close, 1.4 million miles. The comet has never been seen since, considered a lost comet. Well, today is Canada Day. How many knew that? Okay, some people did know it. This is the date in 1867 that the province of Canada, New Brunswick, and Nova Scotia became what we know today as the nation of Canada, and it's celebrated as a national holiday in our neighbor to the north. On the very same day in 1923, Canada suspended all Chinese immigration. You may remember that at our May 6th service, we noted that that was the anniversary of the U.S. Congress passing and being signed into law the Chinese Exclusion Act of 1882. So they were really down on the Chinese back then. It was not just us, it was Canada too. Also, it happened on July 1st, 1870, the U.S. Department of Justice came into being. You know, you'd think it was there from the beginning, but no, it started up almost 100 years after the country got started up. Also, in religious matters, 1879 was the first issue of the Watchtower. All right, Jehovah's Witnesses, oh wow.
And I'm sure this at the end was very near.
At the end was very near. Now they say that Christ, I think their current line is that they say that Christ is come, that the second coming has happened, it just happened invisibly. So Too bad for you.
As most miracles do.
Too bad for you, you just didn't notice, you know, it's like the emperor, you can't see those wonderful clothes he's wearing, you're just not full of enough virtue. 1968 was a non-proliferation treaty, that's been mentioned in the news a few times lately with Iran and North Korea. And in 1991, the Warsaw Pact was dissolved, that was of course the Eastern Bloc's counter to NATO. And then remember our May service? Remember what the American psychologist and philosopher William James said religion is? He said it was one's, quote, total reaction upon life, unquote. Well, this is our total reaction upon life. We have at times said it's our creed, and sometimes we just say it's what we aspire to. We can say it a different way whenever we like. We can reformulate it, so let us know what you think. But, you know, it's always nice to have that mission statement or whatever corporate America is calling it currently. Of course, the most effort is put into our monthly service, but we have other things going on all during the month as well. We have game night every Friday. That is really a lot of fun. If you've never been, you really should. These are board games and card games that if you're a newbie and have never played it before, you can figure it out. Board games that have to do with strategy, taking over the world, being in charge of different countries. Isn't that what you played this last time, Mark?
Yeah.
Yeah. Okay. Also on non-first Sundays in the month, we have our salon. We've been meeting, and this information is on the back page of the bulletin. We may have to move where we're meeting, but for next week, it's still going to be at the VFW Hilton Conference Center right next to the Grapevine Hills Mall.
Yeah, Tim, we're gonna start at 10, a little earlier.
Start a little earlier at
Yeah,
10 next time?
yeah.
Okay, if I say 10:30,
At
we'll
DFW, the same thing.
start at 10, but they're talking about closing earlier, so we're not sure.
Right, we're gonna have to see her.
Anyways, we can always do more, but it takes people with ideas and people who are willing to put their shoulders to the wheel and get those ideas put into action. So give that some thought. Be imaginative. It could just be a one-time event. Come up with something that we'll just do one time, and maybe it works out great, we can do it more, whatever. But put your free thinking into action. There's nothing holding you back. This is not something where we say you do and you do. This is something where we can all do something. Of course, no one, and that includes presenting here at church.
That door's locked, sorry.
Uh-oh. All right. Nothing like being spotted out as latecomers, but better late than never. So anyways, think about that if you want to contribute or become more involved in some way. And there's a payoff in genuine satisfaction of helping each other and working towards a better and more reasonable future. And Merlin, oh, there she is, hiding behind Randall. And Merlin, they are the ones who will take care of, they take turns on that child care Sunday school. But they would love to have somebody else, additional people rotate through with them. There aren't any kids today, so nothing much to do but when we get small kids. We always want to be welcoming to people that do have small children that might not otherwise attend because of difficulty with kids babysitting. And we want to show young free thinkers a good time. They need our help too. So our next service will be Sunday, August 5th, and we're going to talk about this subject, what do we really know at that time? It's really a fascinating subject. And it's one that really had a huge role in breaking down a lot of religious dogma in the past several hundred years and ushering into being the Enlightenment and so forth. And it also involves this really cool word, epistemology. And of course, an adjective, epistemological, and an adverb, epistemologically. I mean, just think if you could learn to say that and get that rolling off your tongue. So come learn what it means and why it's so important. I hope each of you can make it. Bring anyone and everyone else that you would like. So with that, I'm going to turn things over to Rex Burke and Owen Younger. Rex, as I said, is an attorney. Owen is a professional pilot. They're a pair that we heard from in March about their forays into going around the area churches into all our welcome Bible classes and just kind of getting the lay of the land and then making it known that they're atheists and engaging folks in discussion. So that's online, actually. It's on our YouTube channel, so you can go look at that. Rex, Owen?
Thank you.
And here, let me toggle to your,
I'll let Owen do the clicking.
okay?
Rex clicks, it doesn't go well.
You want to take that side? Yeah. So this is obviously a big topic, and there's probably not a way to cover all of this in a few minutes. So what we thought we would do is go through a series of cases over the last 200 years that have really shaped and evolved this law, and it's a little bit of American history as we go along.
Okay, that was my cue.
Just have to, there you go.
All right, so, the original Constitution, you've got the Declaration of Independence, 1776, we all know that. The first governing document in the United States was the Articles of Confederation, and that lasted until, anybody know when? 1787. And the proposed new Constitution was less than 5,000 words. It completely supplanted the Articles of Confederation, and the Constitution as originally drafted contained no Bill of Rights. The original Constitution, as it existed for about 2 years, ended with the end of the Articles. And the only reference in the original Constitution was right here in Article 6 in paragraph 3. So, sure. So, we'll figure it out.
So the point here being that we get a lot of hubbub about the U.S. being a Christian nation, and this comes up, and they'll quote things like the Declaration of Independence and its reference to endowed by their Creator, in the preamble. That wasn't the law of the land, obviously. The Declaration of Independence was merely a letter to King George. But when we did get around to drafting the law, which is the United States Constitution, the only reference to religion is in the negative, and that there will be no religious test for elected senators or representatives, which is a good thing. And so far there still isn't.
Ever.
Right.
Yeah.
And of course it didn't yet include the Bill of Rights. The First Amendment, obviously, we're going to get to in a second, has an explicit reference to separation, and we'll talk about that.
So the debate about ratification of the Constitution got us a pretty, and the Federalists and the Anti-Federalists were arguing extensively, and in order to gain ratification, there was an agreement sort of established between the sort of battling faction. Anybody thinks that politics is divisive today, I've never studied history. The agreement was, we're going to draft a list of explicit rights of individual human beings, citizens, it didn't specify citizens, by the way, that limit the ability of government to intrude into the lives of people. And there were 12 original amendments first proposed, and James Madison drafted them. The very first of those amendments was the First Amendment. And there are two clauses that are very distinct takeaways. This was ratified in 1791, so just a couple of years later. And there are two distinct clauses. We've got what we call the Establishment Clause, and we've got the Free Exercise Clause.
So what's going on here is we're not trying to do away with religion, but we want to keep it out of government, and that was the original intent of this. So Congress makes no law respecting the establishment of religion, meaning Congress isn't going to establish religion. And this wasn't a small point, because if you looked at the countries in Europe at the time, they were all in the business of establishing religion. Certainly the government in England was, and prohibiting the free exercise thereof. So we're not going to tamper with anyone's personal religious rights, but we're not going to do it with the government either. And then, of course, it goes on to talk about free speech and free assembly, which are important here as well. But for our topic today, it's these two distinct clauses that are going to come up again and again in the cases we're going to talk about. Owen, you want to point out what's not?
Yeah, I do. So when we think about religious freedom and we think about how the First Amendment addresses the idea of religion, what phrase really comes to mind in modern parlance? Separation of church and state, right? Separation of church and state. What words do not appear either in the main body of the Constitution or in any of the amendments? Separation of church and state. It's not there. So why is it that we talk about separation of church and state?
Well, we'll get there in a second. I want to say something else about this date, 1791. If you think about what was going on in the country at the time, these were 13 distinct colonies that had just become states. And so most of the people living in Virginia or Maryland or Pennsylvania or Massachusetts or any of these other colonies were primarily residents of that colony, of that state. The role of the federal government was seen as very minimal. That's not the world we live in today, obviously. We have an expansive federal government that we interact with all the time. But at the time, this Constitution and this Bill of Rights was really about fear of the federal government, right? People were handing over some control to a federal government that had previously been solely in their colony and in their state, and so they wanted to assure that the federal government wouldn't encroach on their rights in those states. So this was not, at the time it was drafted, anything about state law. Every one of these states had their own constitution or their own statutory law, and this was really just for the federal government to sit over those states and guarantee the rights of the individuals.
So to underline what Rex said, as originally written, this literally meant Congress. The Congress of the United States of America shall make no law. It didn't say that the city of New York. It didn't say that the state of Pennsylvania. That or the county of Dallas, which didn't exist yet, didn't speak to those things. The way we think of the current state of constitutional law really had it wrong. We're going to cover that just a little bit.
But it got there, and we'll see that.
Eventually got there. So where does this idea of the wall of separation generate from? The answer is in 1801, in the fall of 1801, an association of Baptists in Danbury, Connecticut, wrote to Thomas Jefferson, sort of lamenting that he had not called for any national days of prayer or fasting or anything like that. The two presidents that preceded him had both done that. And the Danbury Baptists were concerned that he wasn't doing that, and it was a very polite sort of challenge, but it was very much, can you explain why?
So, but also this Danbury Baptist group was a minority within Connecticut, and they were also in this same letter complaining about privilege that had been given to some of the larger denominations in Connecticut. They were complaining about state law along the same lines. And then Jefferson writes his response the next year, and this is where we first get this separation of church and state language. I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting the establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. So Jefferson, in his letter, does not address the state complaints that Danbury has. I think that at that point, Jefferson's okay with the state discriminating between religions because he knows that the First Amendment does not apply to the state. They need to take those complaints to their state legislatures. Instead, he focuses on the federal issue, and the federal issue that Owen was talking about the public prayer and such, Jefferson was staunchly against that sort of thing, and so this is where we get that phrase, which is going to come up later, and the court starts quoting that.
As a historical document, this is a very interesting letter. And this is, again, in the modern vernacular, when we speak about freedom of religion in the United States, the phrase we have is separation of church and state. Jefferson literally wrote that there is a wall of separation. In the National Archives, you can go see this online, in the National Archives, the handwritten draft, one of the handwritten drafts that was circulated before he actually made, in January 1st, by the way, of 1802, is when he sent the letter back. That's the letter dated New Year's Day. The handwritten draft actually says an eternal wall of separation. So he didn't use that word in the letter that actually got posted, but it kind of gives us insight into his thinking. So as a historical document, this is interesting, right? But it so happens that when, it's certainly in our modern court system, when the Supreme Court and when federal courts and even junior courts that are trying to understand the law and they're looking at the intent of the words of the law, they sometimes refer to historical sources to get a sense of what the intention was for the words in the law. And that brings us to...
Before we move on, there's another little interesting historical thing there. Think about how, we're talking about 1802, a small Baptist church in Connecticut can write a letter to the president and get a handwritten response with a substantive reply. I don't think that happens anymore.
Right.
Okay.
Right.
If Jefferson had Twitter, it would have been much shorter
So, you know,
response.
I've never thought of this until you said that, but the National Archive has to be going nuts. Like, how do you archive a Twitter tweet?
It's self-archiving.
Right, I guess. Like, you kind of wonder, okay, so,
So Reynolds is interesting. This was a test case in every sense. The law was passed as a test, and then the plaintiff came up as a test. At the time, Utah, all the Mormons moved to Utah, right? And the Mormons wanted to practice polygamy, and Utah was not a state at this point; it was territory. So we've got a federal case because only federal law applied on a territory that wasn't yet a state. And so George Reynolds is actually working for the president of the LDS Church, and he's married several women, and they offer him up as a test case. And so he is criminally prosecuted for violating the federal polygamy law. Or is it bigamy? I think bigamy is the term.
yeah.
And he's violated this law in the Utah territory, and so it goes up. He's convicted, and then convicted again or the conviction upheld at the Court of Appeals, and so it goes to the Supreme Court, where Justice Wade writes
The argument he makes Reynolds, is my right to free exercise of my religion is being infringed by this law.
So he's making a First Amendment argument.
He's making a First Amendment argument.
Saying this criminal code doesn't apply to me because I'm exercising my religion when I break this law. He didn't deny that he had practiced bigamy. He's saying this criminal law is not as important as my First Amendment right.
Yeah, he wants plural marriage, and you're stopping me from doing that. So, the unanimous opinion of the court, anybody ever heard of Justice Morrison Waite? This is probably the only decision anybody ever cites where he wrote the opinion. But this is, if you read the opinion, it's fascinating. He's considering the intention of the words in the First Amendment, and he goes into a kind of a very short discussion of the people advocating for the measure. He refers to it as the measure, and then he cites that
handwritten letter back to the Baptist.
That handwritten letter, that sentence right there, he quotes it verbatim, and then says this: coming as this does from an acknowledged leader of the advocates of the measure, it may be accepted almost as an authoritative declaration of the scope and effect of the amendment thus secured. In other words, the Supreme Court looks at Thomas Jefferson's handwritten letter nearly a century later and says, we in this letter see that this is exactly what the intention was of the free exercise clause and the establishment clause. And this is where, therefore, our interpretation of what the First Amendment means as a matter of constitutional law. And now the highest court in the land has said, we do in fact see that Thomas Jefferson's understanding in the letter is the law of the land. There is a wall of separation.
So this is where we get that wall of separation language makes it into the case law. What started out in just a handwritten letter is now in the case law from the court. The other interesting thing about the holding here in Reynolds is that the court made a distinction between religious belief, which is going to be protected, and then action based on that belief. And some of the examples were, you know, if a church decided to practice human sacrifice and started committing murder, they're free to believe that that's a religious injunction, but if they actually act on it, that action will violate the criminal code. And so the same thing here, the LDS members were free to believe that bigamy was God's will, fine, believe whatever you want. But as soon as you break the law, now it's a separate matter whether we should have bigamy laws or not, we could have a debate on that, but as soon as you violate the law, your action is what you're being prosecuted for, not your belief.
Just for the record, we have no intention of ever coming back here and making a presentation about it.
No, that's not one of our
That's not one of the things, that's not what we're not.
You all can have a vigorous debate amongst yourselves. I like to say I've only had 2 wives and not even at the same time, and that was more than I could handle.
Speaking of wives, this week.
Owen's first wife is here today.
My first wife. I've been told, by the way, not to introduce her as my first wife.
No, I didn't.
My only wife is here today. Our wedding anniversary is this week, and so we are happy. schedule. We were literally in Toronto presenting to another group last week.
And then Kansas City next week.
Kansas City next week.
So she puts up a lot.
She puts in a lot. In every single one of these instances, right, we've got to congeal a body of case law to convey to y'all the current understanding of separation of church and state. So we're working mostly chronologically to get us to the current standard, which is the limit test. We'll get there in a little while. There are a dozen other court cases that have followed this that are very interesting that I would encourage you to go look at if you want to. OIAS is a great website for that. It's a little bit like Justia. If you read it straight from U.S. reports, it's kind of complicated and a pain, but they do a good job sort of explaining the facts of the case, and I find them very interesting. Questions about whether religions that want to conduct animal sacrifice are allowed to do that, voodoo religions and things like that.
Peyote cases.
Peyote cases that was one in the 80s. So there are some follow-on cases, but the basic takeaway here is that the Supreme Court has said that Thomas Jefferson's understanding and his words from that letter are our understanding, and that now becomes part of the case law, that there is in fact separation of church and state. This is really where that...
Well, and still here, we're only talking about federal actors, federal law. The states are still a free-for-all at this point. And we're going to talk about that.
We have to talk about how the states now, and for that matter, government at all levels, gets us to how the Bill of Rights now applies to everybody. So this is why the city of Dallas can't pass an ordinance infringing on your freedom of speech or your freedom of religion, and here's how that happened.
So we're sitting back, let's rewind a little bit back to 1870. So in 1870, what's going on is the war is over. We've got all these Confederate states that want to be readmitted to the Union, whether they like it or not. And one of the conditions to be readmitted to the Union, obviously the abolition of slavery, but they've got to ratify the 13th, 14th, and 15th Amendments. And so this was really sort of done over the objection of most of the people living in those states at the time, but it did become the law because they did opt back into the Union. And a quick reminder, the 13th Amendment basically abolished slavery. The 14th Amendment extends equal protection, well, it does several things, but for our purposes, it extends equal protection of the law to all people living in the states. And then the 15th Amendment basically secures the vote for freed slaves. Now, we know it was nearly 100 years before that had any practical effect. Even the 15th Amendment specifically only says male slaves, so there's no gender parity at that point. But we wanted to talk specifically about this 14th Amendment and this idea of equal protection. The idea of the Due Process Clause and the Equal Protection Clause of the 14th Amendment was really trying to extend those rights of due process and equal protection to all people at the state level. This is the first attempt to take federal law and really reach into state actors. And then we're going to see a whole series of cases, because it didn't immediately give all 10 of the amendments in the Bill of Rights to apply to state actors. But what happened instead was a series of test cases that really over the next 100 years, one by one, incorporated the Bill of Rights and made it the law of the land that they applied to the states. And we'll look at some examples of
So
that.
constitutional lawyers today, a professor of constitutional law would in some cases call this nationalization. When I studied constitutional law in college, nationalization
Or incorporation.
were used. These three amendments, so we call these the Civil War amendments. They immediately, the amendments took place, they were ratified immediately after the end of the Civil War. The object of the exercise, if you think about the state of the government at the time, the leaders nationally wanted to find a way to make sure that states could never infringe on rights again in a way that could get you to something like slavery. So we are now saying that no person will be denied equal protection or due process under the law, under any circumstances. And that's really what that means. Okay, let's jump forward. So case review number 2 is Everson versus Board of Education. The facts in this case are actually pretty interesting. It's something you could imagine almost being a contemporary question. And remember, this is 70 years ago. There is a petition about public payment of busing costs for private schools. So this was
New Jersey.
New Jersey.
So what's
It's in
going
the
on
Northeast.
in New
You
Jersey,
can't trust Yankees.
the state of New Jersey is giving, and these are payments directly to the parents to cover the cost of kids riding the bus to school. Seems reasonable. The problem is, about a quarter of the kids are going to Catholic schools where they're learning Catholic dogma, and there are taxpayers, notably Mr. Emerson here, who is a taxpayer who says, I don't want my taxes paid to the government to be used to fund education in Catholic schools, even though it's just for busing purposes.
So the idea was that the government could pay to send kids to school, pay for the busing cost to send kids to school. The argument that Emerson made was 96% of the schools that you're sending kids to that are private schools are Catholic parochial schools.
So let's pause there for a second. The reason the landscape of parochial schools doesn't look like that today, overwhelmingly Catholic, the reason there weren't so many private Protestant schools is because the public schools were having Bible reading and prayer, and so the public schools were a free-for-all for Protestants, and so the Catholics set up all these private schools. Obviously, it looks different now here, and we'll talk about that. But the Supreme Court, or actually the lower court, had allowed the public funding and said it wasn't a problem. Mr. Emerson appeals to the Supreme Court, who upholds the lower courts. And Owen, your take on this was a mixed bag.
Yeah, this was kind of a loss in the short game, but it's a win in the long game because we are incorporating the free exercise and establishment clauses into the national body of law so that they're applicable now at all levels of government.
So remember back to 1870 when we passed that 14th Amendment, and I said it didn't immediately bring in the entire Bill of Rights to the states. So, here we are 80 years later, and we're finally explicitly incorporating the Establishment Clause as due on states. Now the court did that, which is great. They incorporated the Establishment Clause as applicable to the states, but they didn't actually overturn the ruling against Mr. Emerson. And the logic that they used was, if you read this opinion, is that they gave a couple of reasons for why this was. One is that the payments were made directly to parents. It wasn't made to the church or to the church school. And so they thought that was determinative. And the second thing was that the payment for the busing was made to all students. It wasn't just made to the students in the Catholic schools. Whether the student went to Catholic school or public school, they got the bus payment. So even though Mr. Emerson lost his case, this is a huge landmark moment when we're establishing that the Establishment Clause does in fact apply to the states. Another interesting thing here is that this was a 5-4 decision. The court was very evenly divided on this. And 4 of the justices thought that this was in fact a violation because the whole reason the Catholic schools are set up is to teach Catholic dogma. And if the government funding, even if it's the same funding that they give to the public schools, is explicitly providing a religious alternative to a public education, and then 4 of the justices assented. So this could have gone the other way, but they all agreed on this, which is good. Both the majority opinion and the dissent agreed that the Establishment Clause applies to states.
So there's and I don't know why I didn't make it into the presentation here, but anyway, Hugo Black wrote the opinion of the court. If you are a student of constitutional law, Hugo Black is a name that comes up a lot. That man was able to write just stellar prose. And his reasoning was pretty solid. And I get the distinction that he argues for, which is what Rex is talking about. And I think maybe the court did the right thing here. But in the short game, this might be viewed as a loss by people in our community, but the big picture, right, the effect on constitutional law was the nationalization or the incorporation of the Establishment Clause into every level of government, not just at the federal level.
And most of the progress has been made since then.
Right, most of the progress has been since then. So the next case is Engel v. Vitale, and unsurprisingly, when we're looking at 20th century case law where cases matter, we find Hugo Black's name again. He wrote the opinion in the court. He was on the court for a long time.
So what's going on here is the state of New York had actually created their version of the school board for the state, right? They came up with a prayer that all the students in the school could say every morning along with the Pledge of Allegiance. And in several of the levels this went through the courts, they actually made the argument that this wasn't a religious prayer, so I wanted to read it. This is the allegedly not religious prayer. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Amen. That's the allegedly not religious prayer that the state of New York, and they said, well, it's voluntary. The students are all led in this prayer, but they don't have to say it, so that was their...
And the argument was, we don't say which God.
Right.
Like, we don't identify the Christian God or the Jewish God or the Muslim
The
God.
Almighty One. And in fact, Mr. Engel, the
Not even
plaintiff,
the atheist God, right?
right, Mr. Engel here was in fact a Jew, and he objected to this prayer.
Yeah. So Hugo Black, a man who can put, it would have been nice to meet him. I'm going to read it. I typically don't like to read the text on the slide, but this is very powerful. He says, in his opinion, for the majority, when the power, prestige, and financial support of government is placed behind a particular religious belief, the indirect coercive pressure upon religious minorities to conform to the prevailing officially approved religion is plain. Coercive pressure. When a Supreme Court justice uses a phrase like coercive pressure, an earthquake is happening, okay? That man could write.
And actually elsewhere in this opinion, he talks about how it doesn't have to be a requirement, because the state was relying heavily on this idea that it was voluntary, that any student could just choose not to participate.
Even if it was voluntary.
But he says no, that if it's the promotion of religion, even including this in the daily activity, is promoting it, it doesn't have to be it doesn't have to be mandatory to be promotion. And that was another important thing that has been relied on in later cases. So subsequent to this, and we don't have time to go through all of them, but there are a number of other cases that have picked up on this prayer question in the context of high school graduations, in the context of football games. Now, you can go to East Texas and still find this violated, but the law of the land is that they're not allowed to do it in an official capacity. Now, student-led prayer might be okay in things like Meet at the Flagpole, where it's not faculty-sponsored, it's student-led, and it's not faculty-directed or scheduled. But if it's a situation where the faculty says, okay, now here's our valedictorian who's going to give a prayer at graduation, that's no good. But again, it still happens all the time, and that's the sort of cases that even today the FFRF is still fighting those where they happen in places like Alabama and Georgia.
Yeah, I can still remember as a child, and I'm 45, I'm not that old, I can still remember as a child in the 70s and 80s, hearing over the loudspeaker in the mornings, the principal of my school would say a prayer.
I never experienced that. So
Yeah, so it's you know.
And remember, this is New York. This isn't Alabama.
This is New York State. This was New Hyde Park, New York. Yeah, crazy. All right, so this gets us to Lemon.
His actual lemons. The man's name was Lemon, but Owen shows actual lemons. You could have shown Mr. Lemon, but
I could have. I looked for a good picture and decided this was funnier. I'm all about funny. By the way, I'm the handsome one too.
Right.
So bad facts sometimes make for bad case law. This is the current state of the law. This is the current precedent. All the way back to 1971. This is the current precedent for how to sort of evaluate whether a law is acceptable in terms of whether it violates either of the two religion clauses.
So this is 1971, and what's going on here is Mr. Lemon is a taxpayer in Pennsylvania. And Pennsylvania has this law where they are reimbursing the Catholic schools, or it's private schools, but they're largely Catholic, for the cost of textbooks and the cost of teachers in certain cases. So you've got tax money being directly paid to Catholic schools. And Mr. Lemon, as a taxpayer, objects to this. And so the court sides with him and gives us this three-pronged test. And they say, if we're going to evaluate whether a state law violates the Establishment Clause of the First Amendment, we're going to look at three things. And this is an or test. So if any of these three things apply, then the law is unconstitutional. The statute must have a secular legislative purpose. It can't be for religious reasons. The principal or primary effect of the statute must not advance nor inhibit religion. And in Mr. Lemon's case, with the funding, they didn't really find a problem on 1 and 2. What they found a problem with is on this third one, the statute must not result in an excessive government entanglement. Because all of these payments and then this making sure that the money was going just to classes like math and history and not to the religious classes, that was excessive entanglement. And so this is the prong that actually brought down the Pennsylvania statute in question. But we've got this new 3-prong test, which is 3 different ways to find a state law invalid. And since this time, in the last 50 years or so, there's been a lot of examples of all 3 of these being used.
Yeah. So this is the precedent as it exists today when it comes to sort of government intrusion into religion. That precedent still stands. There have been a number of cases that have followed on from this. If you want to go sort of look at precedents, but this is the one that everybody still sort of cites.
And a lot of the states at the time had similar laws, so
Yes.
this opened up a thing.
A little bit of additional background too, to kind of understand why I say that difficult facts make for difficult case law. The idea in Pennsylvania was that the state was going to reimburse private schools for the teaching only of secular subjects. So Rex kind of made a reference. We're gonna help you accomplish the instruction in mathematics and the instruction in grammar and the instruction in
Right.
whatever.
When you have Bible class, we're not going to pay
We're
for
not
that.
going to pay for that.
And when you have chapel, we're not going to pay for that. But that's where the excessive entanglement comes in, because how can you say, you know, how many minutes of the day were secular teaching versus how many minutes were religious teaching?
Yeah.
And when you've got a nun teaching the class, you know, how can you possibly police how much of that is getting in, even in something like mathematics?
Right.
And the court articulated that excessive entanglement.
Yeah.
You know, and this has come up even in very recent years. George W. Bush talked a lot about faith-based charities, right? And if you have a natural disaster and the group comes in and they're, you know, doing first aid and they're building housing, but they're also passing out Bibles, when does that become excessive entanglement? How do you parse out the secular purpose from the religious purpose? And that's been more litigation, you know, using that problem.
Yeah. Okay, so the last case we'll talk about is the Cape case.
I think you're more familiar with the facts of this one.
Yeah. So, does everybody really sort of understand the background facts of the case here? Okay. The court, and I, in an email exchange with Tim earlier in the week or last week, one of the subjects that came up was I'm surprised that several of the liberal justices on the court sided with the majority. And I thought about this, don't hate me, but I think maybe the court did the right thing here. And there are some deeper questions we have to
Well,
get.
it's that bad facts problem again.
Right, it's a bad facts problem. Bad facts lead to bad case law.
So Colorado had this law that about half the states do at this point that prohibited discrimination against, you know, if you have a public business that's open to the public, you can't discriminate your customers on the basis of sexual orientation. That's a good thing, and about half the states have that law. But Colorado also set up a commission to enforce this law, and they were the defendants in this case. And the commission, the court found that the commission was not acting neutrally with regard to religious beliefs, that when they went to the cake shop owners, so much of the language was hostile to their religions, and that in weighing these cases, they needed to be neutral. And that's really the holding of the court here. They basically punted because they didn't think that the commission had acted appropriately. The good news is they absolutely upheld the constitutionality of these laws that say you can't discriminate on the basis of sexual orientation. So that's not a loss in this case. Now, these particular plaintiffs lost, but they lost on, or I'm sorry, the law wasn't upheld, but it was not because of the constitutionality of the law, but instead it was because of the commission's behavior.
So this is really, according to the court, this is really a question of balancing free expression against free exercise. So,
Two different parts of the First Amendment.
right. Can you compel someone to say something or transmit a message that their conscience refuses to allow? And this is, all hypotheticals break down. Okay, all analogies break down. Let me pose an analogy to Rex and I have talked about today. If you are Ansel Adams, you're a photographer, Okay, we've got to suspend disbelief and just set up the thought experiment and then think about the thought experiment. That's the purpose of my postulation. If you're Ansel Adams, you're a world famous photographer and you live in a time frame when the Nazi government is running Germany. And the government of Nazi Germany comes to you and says, we want you to deploy your significant photography talent to document the amazing beauty of our concentration camps at Dachau. And we want you to photograph that, create a beautiful photo album for us. If you're Ansel Adams, can you say no? And I think...
Probably not in Nazi Germany.
Right. But assuming that you could say no without any physical repercussion or otherwise to you, like, do you have the right to say no? That's the question. So this is a somewhat tortured analogy, but as a thought experiment, it gets us to the root of the problem. At what point are you a public accommodation, okay? And at what point do you have the right to deny your services to someone for a purpose that you find repugnant?
But Ansel Adams never had a storefront saying, I'll take pictures of whatever you want.
Right, sure. And
He was artist for his own sake, and if people liked his stuff, then they bought his stuff.
Sure.
In this case, the guy's got a bake shop, and he makes wedding cakes for people.
sure,
And nobody gets a wedding cake off the shelf.
I get your point.
Did this decision, in your view, you read the decision, it seemed like they waffled on whether or not a cake is speech.
Right, I think that question is ticking, and I also think there's a question ticking about, custom versus assembly line, like what, we had civil rights cases in the 60s where people were sitting at a lunch counter ordering a sandwich, and the person says, no, because of my beliefs, I'm not gonna serve a black person. But is there a difference between a wedding cake and a sandwich?
But the sandwich is made to order too, for that specific customer.
Right, and no one has ever won that argument on the sandwich one. And that's why.
Subway says they're sandwich artists.
Yeah,
But,
right.
They do.
someone now is trying to use this same law for refusing to do floral arrangements for our baby.
Sure. We're not done with this. And the decision that was made here really wasn't on the substance of this question. The decision that was made here was on the behavior of the commission in Colorado, which clearly showed bias.
Well, of course, the dissent pointed out that that was BS. That was
Right.
a BS argument. So
Right.
I'm thinking maybe more weight to put on the fact that in Colorado, at the time of the infraction, gay marriage has not yet been legal.
Right, they had to go to another state to get married and come back.
And Obergefell, how do you say that?
Mhm.
What's the pronunciation? That had not come down yet.
Right, that happened between the wedding and this case, right? So we're gonna see this again. This question's not really answered yet.
What's the pronunciation of Obergefell and Obergefell? You know?
Well, I mean, basically, that law's prohibiting.
No, the pronunciation. I don't know.
Oh, Obergefell,
Is it Obergefell?
that's what James Hubbard says.
So- Yes, sir.
I'd like to very quickly go back to the 14th Amendment
Mhm.
and equal protection under the law, which is very pertinent today to immigration things.
Right.
In other words, does equal protection under the law apply just to citizens?
It does not
It does
say that
not.
it does. I would argue that
Or
it applies
is
to
it anybody?
every
Right.
human being.
Right, it has many times been applied to everyone in U.S. territory.
Yeah.
In fact, this comes up in the Guantanamo cases, I mean, it's not a religious
That,
issue.
really applies to all of it.
So the bottom line is that conservatives, and particularly religious conservatives, are very happy with the outcome here, but they're ill-informed or they really are being disingenuous. The Supreme Court punted, okay? The argument that we would make from our side is that discrimination is wrong. We actually have legislation to that end that goes back to the Civil Rights Act, where there are an enumerated set of protected classes, protected groups, okay? And creed, religion, national origin, et cetera. There are 7. The question is sexual preference one of those? And then the forward question that has to be considered, the next time this comes up, and the Supreme Court didn't think this was ripe enough to actually wade into this and try to answer the question in a way we would like, that is more substantive. But the first question is, what is a public accommodation? If you were a hotel, the Civil Rights Act was thinking about things like, I am a black man and I'm driving from New York to Kansas City and I have to spend the night. And if I can't find a hotel, then I can't actually make the drive because it's against the law, it's vagrancy, to sleep in my car, right? So if a hotel can deny me the right to stay there, then that creates a problem for interstate commerce, which allows the Congress to go in and make law because they are empowered under Section 8 to do that, Article 1, Section 8. So they defined public accommodations and said, if you're a public accommodation, then you can't discriminate on these bases or it's a violation of interstate commerce. And they created protected groups as part of that law. Now, a number of states have done the same thing, and they've said, we're going to add other protected groups.
Sexual orientation.
Right, and sexual orientation is one of them, and most states now, certainly a majority of states, not all, have said that LGBTQ, that's a protected, sexual preference is a protected, I'm sorry?
20 states.
Yeah, it's about half.
Is it 20? Okay, maybe I had it upside down in my head.
And then some municipalities as well have done
Yeah.
that, even the state didn't.
So the future outcome, and we're by far, we are not done with this yet. This is not a decisive precedent by any stretch. The future outcome really is going to circle around those two bullet points right there. But the thing that matters is how the court is going to draw the line between free expression and free exercise. What constitutes art? I get it, and I deliberately created a difficult analogy to ask about ants' ladders. I'm deliberately doing that. But at what point does a person have the right to say, I'm not supporting that, and where does that line get drawn? And the answer is, I don't know. What I do know, and I know this over and over and over again from history and from the case law, is that bad facts make for bad law. So we're not done with the law by a lot here.
Yeah, and we may ultimately end up with something like Mr. Reynolds and his bigamy, where the court says, you know, you can believe anything you want, but when your actions violate the law,
Right.
then that's where it goes too far.
Ultimately, I think that's
Right, but when we're talking about not doing something, not making a cake, then the action is the discrimination, and that's.
That's what I was going to ask, how did they differentiate free expression if the guy wanted plural marriage? Isn't that an act of his practicing his religion?
That's really freedom of association.
Yeah.
Yeah, it is. And to Tim's point, this was before, before the law allowed gay marriage, and so that may have affected his feeling emboldened to take that stand.
It's my opinion, and I think Rex is too, but I won't speak for him, I'll speak for myself. It's my opinion that this made our presentation because it's the most recent case, okay, that we've looked at. But I don't see this as impactful in any way to the state of the law with respect to the two religion clauses in the First Amendment. I think this is almost unimpactful to that.
Because of the reason for the holding.
Yeah, the Supreme Court literally punted. They refused to actually answer the question. They said that the Colorado Civil Rights Commission acted in a discriminatory way, and therefore they were setting aside.
Hostile to religion.
Hostile to religion.
It raises the question though, is that, what if this baker had said, I make wedding cakes only when you come with a letter from a clergy person of these denominations. I don't do other denominations.
Well, that's another, so this is
That's
an
kind of
example.
religious discrimination, but
I only
it's doing
make,
it in a negative or in a positive way, kind of like in a state where it's illegal to have an upcharge for using a credit card. They just say, oh, we can have an upcharge for a credit card, but we have a discount for cash.
right.
Well, there are churches that will only let you use their church for your wedding if you've counseled with the minister, or if you're baptized in that denomination, or if you haven't cohabitated, or, these are all different rules.
As a separate point, on the thing about having a discount for cash, I think, didn't they just recently rule that to be illegal? In a different court case?
I don't know.
I'm not familiar with that.
Yeah.
There's still plenty of places that offer
I
discount
mean,
for cash.
that's something, that's trade benefit. I mean, it's not belief. It's not a religious belief, it's just how you do business, how you make money.
Right.
So I don't think that would be an issue, right?
Well, certainly the cash discount wouldn't be an issue for
Right.
either of the two religions.
You might be running afoul of your master agreement
Yeah.
and the credit card process.
So there's a lot of stuff that we haven't talked about that has pretty good case law, and we didn't talk about them of reasons. We didn't talk about the Ten Commandments, we didn't talk about public crosses, nativity scenes, the Pledge of Allegiance, intelligence design in school, we didn't talk about it, God we trust on currency. For the most part, these have not risen to the level of the Supreme Court, and that's why
I think we are one good test case away from getting rid of all of those.
I think
It's so clearly a violation.
we need a good set of facts, okay? But I think some of these are pretty close.
One of the arguments that the people putting up these monuments on courthouse lawns of the Ten Commandments and even in classrooms, they argue that this is for historical purposes. It's part of our legal history, not for religious purposes. But the thing is, the very first commandment says God is one, and no gods before me. That's clearly explicitly monotheistic, and even a Hindu would have a problem with that. The Ten Commandments are funny to me too, because Christians don't even really follow them, right? Like most of them don't care about the graven images. Well, their churches are full of graven images. Most of them don't care about the Sabbath command. They've ignored that for 2,000 years, and so.
And coveting.
Yeah, coveting. I mean, there's a whole branch of Christianity that says that's a good thing, right?
Yeah.
Let me ask you
Can you
something.
expand on what you said about, do you think we're one test case away from?
I just think this is
Where are
such
we
a.
at currently with respect to something going to the Supreme Court? Is there a case out there that may go, or?
I mean, there's always cases. I know FFRF keeps bringing these, and I think we just need a good one. So it would take one pronouncement from the court to say this is clearly a violation of the Establishment Clause, and they all need to come down.
Here's a good,
But of course, if you have another extreme conservative on the Supreme Court, all that's gonna go away.
Right, we're gonna have a problem.
And the other thing I want to mention is about abortion when it was legal. I had a nurse that said that she was, as far as a delivery of a baby, that if there was a choice between the mother and the baby, that she would not allow she would not service if they got rid of the baby, because that should be God's choice. Now, is that violating her freedom of religion? If indeed she doesn't get fired?
I don't know how to answer.
I don't know.
That's a,
And there may be a difference there if she's in a private hospital or a public hospital or a
Public.
so that's a different body of law. There's a standard of care that's expected when you're a patient. And someone who violates that standard of care is potentially is even guilty of criminal actions against you. And if you die, then you might be guilty of homicide at some level. I mean, that's a whole complicated conversation.
Your comment, though, I think it makes a good point to everyone in the room and all of us. With Kennedy's resignation, we are facing an important moment in history. And to the extent that we all need to be paying attention to this stuff, because it really matters, and it's about to matter a whole lot.
Yeah.
There are entire classes of people that are in real fear of losing their rights, and we're all sitting watching. And so
Yeah.
we've got to figure out
We have to be.
how to get everybody to care a whole lot more about this.
Yeah, we have to be engaged. I want to talk about the Ten Commandments display and offer an observation. In a lot of cases, many examples of, we didn't talk about this in terms of Supreme Court case law because a lot of the stuff got resolved at lower levels without ever needing to get to the Supreme Court, okay? So there is no Ten Commandments display precedent from the Supreme Court because most of the time, lower courts have done the right things and Christians have looked around, almost all of them, and said, okay, we're good with that. Now, there's one example, Roy Moore, who ran for the Senate in Alabama, right? And he was, of course, it's Alabama. He was defeated. He was a former Supreme Court justice for the state of Alabama. Do you know why he was removed? Does anybody know why he was removed? He was removed because he had a Ten Commandments display that he was ordered to remove and wouldn't do it. And so the judicial board in Alabama removed it.
Their equivalent of impeachment.
Yeah, they basically impeached it. There are other examples, public crosses, nativity scenes. For the most part, right, the Freedom from Religion Foundation, of which Rex and I are members, and right now it's a great time to sign up because we're looking at Anthony Kennedy.
Because this matters.
Because this matters a lot. Most of these things were resolved correctly at a lower level and never had to get to the Supreme Court. The intelligent, like, I wanted to do Kinsmiller v. Dover, like, I wanted to do a bunch of cases. There are several cases, Michael knew down in California, the Pledge of Allegiance, but they never got to the Supreme Court. And
Or lost on standing.
Newdow was thrown out.
The thing about the Ten Commandments displays, the pledge, the God we trust stuff, a lot of this stuff does not go back to the founding of the nation. This all came in the 1950s and 60s. So the pledge under God, I think it was what, 54? That was
Yeah, 1954.
Right.
People talk about it being history. My ass, it's not
Right.
history. The original Pledge of Allegiance said one nation indivisible. Yes, it did. That's the way it was originally written.
And this didn't appear. This started appearing on the coins in the late 19th century, but didn't appear on paper money until the 1950s.
Yeah.
And in all the Ten Commandment displays, it was really, there was a group in the 50s and even early 60s that started putting these out.
Those filthy, atheistic red commies. We've got to distinguish ourselves from them.
Right.
Yep.
Teddy Roosevelt, when he commissioned the famous $20 gold pieces, the St. Gaudens, the very first ones did not have the motto on it.
Yeah.
Yeah, felt that it was, and I mean, really, it's arguably blasphemy. Why aren't they objecting?
Right.
Yeah.
As an interesting little historical note, you might get this on Double Jeopardy sometime. The very first coin that had the "In the God We Trust" was actually during the Civil War, and it was the 2-cent coin. So the United States came out with a 2-cent coin that was a little bit bigger than the 1-cent coin, and that was the first one that had the "In God We Trust." Now, the 2-cent coin never took off and only lasted a few years, but that was the first one.
I'm sure you have a couple of these.
I do.
Yeah. Rex collects coins.
It only
So
lasted
I collect 2,000 coins.
Oh, it's in the ancient.
Yeah. So, there are a fair number of things we didn't talk about. I kind of wanted to
I love the way
explain.
you have slides that we didn't talk about it, then we talk about it.
Well, stuff that we didn't do a case review on. These subjects are far more interesting, but they're far more interesting because they're far more obvious.
And you could, yeah, not as impactful as some of the other things, public education and reproductive rights.
Right.
Okay?
So I think that gets us to really the last question, and this is where we're going to leave you, other than questions. And the question is, how do we balance two different kinds of freedom that may be in conflict? I am, if not entirely sympathetic, I am willing to listen to the complaint of a Christian who says, my conscience is troubled because you are asking me to do something that violates my conscience.
Well, so think about the taxpayer problem, right? So several of the cases we talked about, the litigant bringing the complaint against the state law was doing so because they were paying taxes for something they didn't believe in, the religion, the establishment of religion in the case of funding religious schools or something like that. But the Christians will make the same argument, right? I have taxpayer standing and my tax dollars are being used for something that violates my religion.
Right.
Which, could be anything from the death penalty to publicly funded abortion to teaching evolution in school. And so the court's going to keep hearing these questions, really with the same argument from both sides.
So I think we probably took more time than we were allotted. Does anybody have any other questions for us? Yes, ma'am.
Well, I have a suggestion for those who are concerned about the replacement of Kennedy on the Supreme Court. Write a
Move to Canada.
postcard, call, Twitter, Facebook, your senators, and any other Republicans who might support it, not waiting until after the elections to make the decision.
I hope that would have an effect. I am.
Not my senator. Have you met my senator? No. Maybe somebody else's senator.
Neither. We have two.
Right.
Neither. I
Yeah,
don't.
it's-
I'm not even thinking of it. Okay.
Yes, sir.
Yes, agreed. We
Oh.
can all do one.
I just wanted to, ask a question and make an observation. Seems like the Lemon case
Yes.
would be a pretty good case against property exemptions for churches. For example, property taxes, their property being exempt. Wouldn't that, from an attorney's point of view, wouldn't it make sense if I argued that, okay, we got this county tax base, and they have to have so much money. Because you're exempting the church property, let's take downtown Baptist Church and the Methodist Church, probably $1 billion in
It's
value.
costing everyone else more.
Yeah, which is tax-free. In effect, I'm paying their share because they're taking a little more from me because.
Well, and they're using the same public services. They're using the police and the fire and the roads and the
Right.
water delivery
Right.
system and all the same public services that the tax base pays for without actually.
They're getting it for free,
Well,
right?
I'm curious why nobody's ever challenged
No,
that.
I-
Well, there was a referendum in Colorado some years back. and-
Yeah, it's been
I mean,
challenged.
it just seems like it's so obvious it's in your face. Why is it
I
happening
mean, just
every
follow the
day?
money. I mean, it's such a huge political issue. I think it will eventually fall. I think you're right. I mean, even something as, yes, obviously the tax thing, but think of something like, I can't buy beer, is it Nunya? I can't buy beer on Sunday in Texas. Well, that's clearly a religious intent. There's no other basis for that
Well, the
law.
blue laws used to be you couldn't buy anything.
Right.
Right, so
Right.
we've made some progress.
Yeah, some progress.
Yes, sir.
Another issue I didn't hear today, and I think we touched on with the 14th Amendment,
Mhm.
and I read somewhere that corporations have tried to work this into Supreme Court decisions, that amendment only used the word person without a definition of what a person is.
Yeah.
Corporations are trying to claim human rights. You can't intrude to examine our business because that would violate the right of a person to unreasonable search.
There is an interesting argument to be made there. The idea of a corporate entity is
It's an artificial person.
well, so not a
But they
natural
try to
person,
say rights
but
of a
that,
living
but
person.
that, but that person, so that entity does still have rights. And certainly has the right to transact business, to be a party to contracts.
Well, and Citizens United is the furthest stretch we've had of that. You know,
Flood them with money, we don't care.
extending the First Amendment free speech, and in the Hobby Lobby case, same thing.
Yeah, that may be what he's referring to, Hobby Lobby, where a corporation gets religious.
Yeah.
Right, so, yeah, Citizens United gives First Amendment and, free speech, and then Hobby Lobby gives First Amendment, religious.
There is more case law that's gonna have to come on that. Right, so I understand the question, and I would say that we don't have the right answer.
Well, and there are fiery dissents in both of those cases, so clearly the
Yeah.
court, you've
But
got justices
I
that
think
agree.
The
About that fewer than-
entity needs to be grilled on that too.
Yeah, so the one thing that I'll say, in spite of the fact that Kennedy is stepping down, and this is the last thing I'll say, or else there are other questions, but the trend over time has been what? Has been toward progress, right? The trend has been toward liberalism. The trend has always, there have been setbacks, okay, but the trend has always been in the correct direction, right? To the direction of modernity, to the direction of conscience,
Enlightenment.
to the direction of enlightenment, right? To the direction of liberal thinking, right? It was inconceivable in 1918 for people to stand up and advocate for LBGT. It was inconceivable for people to stand up and advocate for interracial marriages, okay? It's been within living memory of people in this room that
All of those
anti-discrimination
laws
laws were thrown in, okay?
Hamilton
So,
fought for 20.
right. So as traumatic as the idea is that this sitting president might actually fill 3 Supreme Court seats or more, we can look to the fact that progress has been constant and has always been in our favor in the long term. The best that we can do is live out loud, is make our voices heard, is make sure that the political leaders know what we think and that we respectfully share our disagreement and try and help people understand why we think. Thinking, right, and reasoning. That's
I think it seems that some of these conservative issues